There's really two ways that custody can be modified in Minnesota. The first way is by agreement. So if you and your co-parent are choosing to modify custody and you agree to do so, that's the first way. The second way that you can modify custody is through formalized litigation proceedings. In order to do so, you would have to show that either the child is subject to some kind of physical or emotional endangerment, or the child has been integrated into the home of the non custodial parent. The process by which you do that would be filing a motion with the court and then having the court hear and decide your matter on its merits. The formal process for modifying custody involves filing a motion with the court. And then you must meet your evidentiary burden. The burden that you have to meet is either a integration standard or an endangerment standard. Once you file your motion with the court, you show up for an initial hearing, and the judge makes a determination about whether you've met your evidentiary burden. If the court determines that you have met your burden, then the matter is set on for a contested evidentiary hearing sometime after that first hearing. The evidentiary phase is very much like a contested trial. And so it's typically 1 to 2 days in length. And we examine witnesses, we present exhibits, and then the court takes the matter under advisement for a ruling at a later time. If a custodial parent moves out of Minnesota, they do not lose their right to exercise parenting time. In order for a parent who has primary physical custody to be able to move out of state, they either need the co-parent's permission or permission from the court. And as much as possible, when a parent is moving out of state with the children, the courts will try and maintain the same level of contact to the extent possible that occurred prior to the move.